Good evening and welcome to this Tuesday, February 18th, 2014 meeting of the Raymore Planning and Zoning Commission. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let me remind the commissioners, please speak into your microphone for the record and make sure the green light's on. And we'll call roll. Commissioner Anderson.
Present.
Commissioner Burke.
Present.
Commissioner Crane.
Present.
Commissioner Fizer.
Present.
Commissioner Grodsky. Commissioner Hanner. Commissioner Meiske.
Present.
Mayor Kirchhoff.
Present.
And Commissioner Faulkner is present. We do have a quorum. We have no personal appearances scheduled this evening. One item on the consent agenda, acceptance of minutes from our January 7th, 2014 meeting. And unless there's anything that commissioners want to discuss, I would entertain a motion to dispense with the consent agenda.
Mr. Chair, I make a motion that we approve the consent agenda as presented.
Second.
Motion by Commissioner Anderson, second by Commissioner Crane to approve consent agenda as presented. All those in favor, raise a hand, please. 7 in favor, and none opposed, no abstentions. And nothing this evening scheduled under old business, so that takes us into new business this evening. We have one case 14003, Unified Development Code 19th Amendment. This case will require a public hearing, and I think probably as good a time as any. I'd like to disclose that I do have a long-standing personal friendship with the brother of one of the lawyers present this evening. I don't feel that that in any way will affect my decision on the case, though. So simply wanted to disclose that. And Mr. Carteret, since the city is the applicant on this case, if you would present the case to us and give a staff report.
Yes, sir. Thank you. Case 14003 before you this evening is the proposed 19th Amendment to the city's Unified Development Code. Since it is a proposal to amend the text of the code, it does require a public hearing that we did advertise for this evening. A duty to enter several items into the record: the growth management plan, the Unified Development Code, the notice of publication in the journal for the public hearing, a staff report submitted to the commission members this evening, the council work session minutes from May 20th of 2013, the August 19, 2013 council work session minutes and agenda item memorandum, the October 7th, 2013 council work session minutes and agenda item memorandum, and a memo dated January 13th of 2014, the adopted stream classification overlay map, which is dated April 5th of 2006. And Exhibit 10 would be a letter submitted by the South Grand River Watershed Alliance that was distributed to the commission members. We'll briefly go over some of the staff comments in the staff report submitted to you this evening. Back in 2006, in June of 2006, is when the Raymore City Council adopted and accepted the Raymore Watershed Master Plan. This was initially prepared by B&IM Architects, and the specific purpose of the plan was to help preserve the existing hydrologic conditions, enhance riparian habitat, and protect water quality for future generations of Raymore citizens. One of the main focuses of the plan was to protect, enhance, and preserve stream corridors within the city. One of the recommendations from that watershed management plan was for the city to consider adopting stream buffer protection requirements. And there was an ordinance that was approved in February of 2008, and then those requirements were ultimately incorporated into the Unified Development Code upon its adoption in 2009. And the stream buffer protection provisions, they're one of the best management practices that the city of Raymore utilizes to reduce the impacts of development upon the watershed areas within the community. Regarding the proposed 19th amendment this evening, discussions on the stream buffer preservation requirements in our code began at a work session back in May of 2013 when staff was discussing the topic on a council agenda regarding our stormwater discharge permit that we have obtained from the Missouri Department of Natural Resources. And it was at that work session when staff made reference to comments that had been received verbally from the Environmental Protection Agency regarding the city stream buffer provisions and concerns from the EPA that Raymore has exempted, in their opinion, too much land area from being under the requirements of the stream buffer preservation requirements. At that work session, council then directed staff to begin to include information on a development status vis-a-vis the watershed management plan each time a preliminary plat would be brought forward to the council for consideration. So they wanted us to strictly look at, or specifically look at the effects the stream buffer requirements would have on a preliminary plat when that preliminary plat was being considered for an extension. After that initial work session in May, or since that time, there's actually been 4 preliminary plat extension requests that have come forward to the city council. All 4 of those requests have been approved. The first request was approved for a 2-year time frame, and the following 3 requests have been approved for a 1-year extension. After the May 20th meeting, staff was requested to come back to a council work session in August to provide additional information to the council regarding what specific areas in the city are considered exempt from the city's current stream buffer provisions. So we provided a memorandum to the council and a discussion at their work session regarding the properties that are considered exempt. And it was at the conclusion of that work session where staff was asked to arrange for a community forum to obtain inputs from not only the development community, but all the interested parties about the topic discussing removing exemptions to the requirements that are currently in the city code. So following that work session in August, we did provide notice to the development community and interested parties of a work session that was going to be held October 7th. At that work session, there was a lot of discussion, again, from staff on proposals, as well as discussion from the development community and interested parties regarding the proposed revisions to the stream setbacks. After a lot of discussion at that work session, council took no action. They decided to take the comments under advisement. Then in January of 2014, there was a memorandum from staff to the council regarding the stream buffer setbacks, and it was at that time when staff was directed to proceed with proposed amendments to Unified Development Code, which has led to the proposed amendment tonight. Part of the staff report that was submitted to the Planning Commission is a proposed bill, which includes 6 separate sections, each section identifying a specific amendment that we would like to make to the Unified Development Code. So what I'd like to do at this time is briefly go through each one of those sections to highlight the proposed amendment. Starting with section 1 of the proposed bill. This particular section proposes to eliminate the exemption for property covered by a memorandum of understanding. So a development that has an MOU agreement with the city would not be automatically exempt from the stream buffer provisions simply for having the MOU. Section 2 of the proposed bill proposes to clarify the applicability section of the stream buffer provisions. What we propose is to add language that would indicate that a property owner could remove an Order 1 or an Order 2 stream on their property if the U.S. Army Corps of Engineers does not have jurisdiction over the stream, and then the city engineering department approves a plan depicting measures that will be implemented to replace the lost value of the stream buffer. So these are two new provisions that we propose to add to the stream buffer regulations. Section 3 of the proposed bill would clarify how the width of a stream buffer is measured. The revised language is going to allow for the location of the buffer to be modified if the topography or some other geologic feature of the property would dictate an alignment of the stream buffer different than being equidistant from the center line of the stream. The way the stream buffer is currently set up in our ordinance is that the buffer is measured from the center line of the stream, equidistance from the center line, whether it's a stream order 1, stream order 2, the buffer width actually does vary. We're not proposing to add to the overall buffer width. We're not proposing to modify the buffer width. What we're proposing to do is allow, if you would, averaging to allow the buffer to be shifted depending upon the features that may exist on one side or the other of the stream. Section 4 of the ordinance proposes to clarify the filing of a final plat application once a preliminary plat's been approved. When a preliminary plat is approved, the developer has 1 year to come in and file a final plat application. What we're proposing to do is indicate that not only does the application need to be submitted within the 1 year, but it needs to be approved within 6 months of the time it was submitted in order for the preliminary plat to remain valid and be extended for an additional 2-year time period. Section 5 is a proposal that's going to clarify the procedure for requesting to extend the expiration date of a preliminary plat. This proposed language also establishes factors for the City Council to consider in its deliberation to determine if an extension should be granted. So we're trying to provide a little bit of clarification on the process of when a property owner comes in to request an extension for a preliminary plat. And then the final proposal under Section 6 is a request to reinsert a requirement that each single-family residential final plat application contain a minimum of 20 lots when the subdivision is proposed to be constructed in phases. This was a code requirement that was initially inserted into the zoning code back in 2003. It did not get included in the Unified Development Code. It was inadvertently omitted. We would like to have that particular provision reinserted into the Unified Development Code. So those are the 6 proposed revisions in the bill. Staff has submitted proposed findings of fact for your consideration and on the 19th Amendment to the Unified Development Code. The staff recommendation, when the stream buffer protection provisions were initially adopted back in 2008, the city did knowingly take a very conservative approach. We did exempt a considerable amount of land for the provisions of the stream buffer. So again, as a reminder, currently exempted from the stream buffer regulations is any property that has a final plat application approved, a preliminary plat, a preliminary plan which is applicable to a planned unit development. So a project like Alexander Creek or Creekmore has an approved preliminary plan. And then as well, the preliminary plats for property and the memorandum of understanding. So those are the current exemptions for the applicability of the stream buffer requirements. For a number of years, we have been hearing through our permit renewal discussions that the EPA has again had concerns with the number of exemptions that we had for our stream buffer provisions. The EPA would prefer that all undeveloped land over 1 acre in size be subject to the provisions. We're not proposing to go to that length, but we are proposing again to eliminate the automatic exemption for MOUs. Staff did take, we took a very in-depth look at this after our October 7th work session with the development community and interested parties. We considered potential impacts to the property owner, development community, the environmental benefits of protecting a greater amount of undeveloped land along the stream corridors. We did again come to the conclusion that the mere presence of a memorandum of understanding we do not believe should be the sole basis for exempting the land area covered by the MOU, the stream buffer protection provisions. We do have 3 MOUs within the city. Each one was approved for a very specific purposes and specific to the property to which it's written. The Good Ranch MOU was the first MOU that we had, dates back to 1994, and it documented the agreement between the developer and the city on annexation, zoning, density, roadway improvements, and the future land use dedications to the city for public use. The MOU did not exempt the developer from compliance with then existing or future city code requirements. The Creekmore MOU and the Carroll MOU are more current MOUs, and they do both include very specific language that the MOU does not constitute a waiver of any requirements of applicable city ordinances. Again, those MOUs are specific to each of those developments and the items that each MOU covers. We do believe that the purposes for which the MOU was approved should be upheld. So we look closely at the MOU. If the MOU covered a specific aspect of the development, then the city has agreed to that aspect, and we need to uphold that. But we do not believe the MOU should be used as a tool to exempt the property from city code requirements that would otherwise apply. So based upon that, the staff does recommend the commission accept the findings of fact and forward the case 14003, which is the 19th Amendment to the Unified Development Code, to the City Council with a recommendation of approval. That would conclude the staff report at this time.
Yeah. Thank you, Mr. Carteret. And so before I open the public hearing, we would normally ask the public to limit their comments to 3 minutes or so, to not reiterate a position that's been previously stated, but simply note that they're in agreement with that previously stated position and try to keep the proceedings moving. I have a feeling this evening that 3 minutes may not be sufficient, and so I'd like to suspend that 3-minute rule if that's okay with the rest of the commission. No serious objections, but again, I would still like to ask your cooperation in keeping the proceedings moving, and I think I can reserve, Mr. Willerth, can I reserve the right to cut off discussion if it gets out of hand?
Absolutely, sir, you can.
Thank you. Hopefully won't have to use this except to close the public hearing, but at any rate, also if you want to speak at the public hearing, come forward to the podium, state your name and address for the record, and be sure that you're speaking into the microphone and that the green light is on so that we can hear you and get a record. And having said that, let me open the public hearing on case 14003, 19th Amendment to the Unified Development Code concerning stream buffers. Would anyone from the public like to speak on this case? More to the point, would anyone from the public like to be first to speak on this case?
David Otis. I'm with Good Otis, and we are developers of the Good Ranch. It's good to be here in front of you guys again.
Yeah.
Just like to really pretty much state our position, and that really is that we would like to keep working with the city as we have been for the past 20 years with an excellent relationship, and we value how we've worked with the city, and we would like to keep that going. We believe that the memorandum of understanding that we have is a legally binding agreement with the city with which we annex the land to the city in exchange for working with the city to develop the land harmoniously to make a great community development. So with that being said, I'd like to basically just state that that's really how we'd like to continue, and I would like to turn the floor over to Jim Price.
Thank you, Mr. Otis.
I think, first of all, my name is Jim Grice with Lathrop and Gage at 2345 Grand, Kansas City. I'll try to use an easel here in a second. And thank you, Mr. Chairman, for suspending the 3-minute rule, because I don't think a lawyer can say anything in 3 minutes. I mean, that's just the introductory period.
Mr. Willerth and I chatted about that before the meeting.
Well, thank you very much. And it's always nice to be back in Raymore. I've had an occasion to appear in front of boards and commissions in Raymore, as well as Belton and Cass County and whatnot. And as Mr. Chairman alluded to, my brother, my sister-in-law have lived here for more than 20 years.
35
actually.
years.
And down here southeast part of town. So with that being said, you know, this really, there's a little bit of a story here that I think is very important for each one of you to understand, to really adequately communicate, I think, the pieces that David has brought up. David Otis and Jim Otis, Jim Otis' father, came to Raymore and back in basically 1993, would that be accurate? And reached a joint venture arrangement of sorts, Otis Good LP, and to develop the Good Ranch. And I can remember that happened. I was just getting out of law school, quite frankly, and I was driving down here to do something, you know, visit my brother or something. And the Good Ranch sign comes up, and it's a planned unit development, large scale tract, some 1,700 plus acres. In 1993, there was a lot of give and take with the city and a lot of interaction. And in late part of '93, say December of 1993, the MOU that we talk about, the Memorandum of Understanding, was taken up and went through the process. And a quote from your planning consultant at that time, which was Booker, Willis, and Ratcliffe, referred to it as follows. Conceptually, it's a very sound plan, well designed around existing and planned physical constraints, such as the existing topography of the projected thoroughfare road system and the topography itself. The plan itself, this is a full version of it, and
Right.
take a moment right before these tripods set up.
Yep. Feel free to bring that over. I don't know that the whole room will be able to see it at once. Sure, you can.
But this is the map, and this has been the map that was attached. This is the map that was attached to the MOU.
Right.
But this is also, I mean, this is the plan, right? And maybe you all have seen this, maybe you haven't.
I think most of us actually have seen that at times.
It's been,
Mr. Cataract?
I mean, it's been passed around. I had the opportunity.
Oh, I'm sorry. I'm slow to catch on. You're out of microphone. If you'd like, Mr. Willerth, can Mr. Grice use your?
We'll deal with it.
Okay, thanks. I always forget. I can hear you, but doesn't necessarily mean the recorder
Doesn't help
does.
the record, right?
Right.
So
Thank you, sir.
this is your master plan document that's attached to the MOU. It was attached in 1994. That's the subject of the comments from the Booker Willis professional. And as you can see there, one of the references in the staff report was that the MOU makes no provision for stormwater and stream buffer. And that is a point of contention that I think the Otis Good organization would take contention with. As you can just see, there's 22% of the total land mass that's set aside for stream buffer and stormwater detention. If you look there in the lower portion there, that big green buffer, there's a fairly large, sizable lake there, and you all are familiar with this property. I'm sure you've driven it.
Mm-hmm.
It's a fairly large expanse, and there's a fairly generous allocation put together a long time ago to deal with these issues. But the point is, the plan was put together for centralized stormwater detention and to handle the stormwater runoff in a very orchestrated fashion, to take into account the whole tract, to take into account really the gateway of Raymore. At the time when the MOU was entered into, there were mere plans, but not physical construction of the North Cassway interchange. I know the other day I met with Gib Good, and Gib was talking about conversations he had with, was it Senator Caskey, about the location of where that needed to go. That's kind of a name from the past too, right? Senator Caskey, who was such a prominent leader in this area for years. And so this project's got a lot of history, but it's also got a lot of success, and I think one of the things I'll just mention, We've looked at this, and we've looked at a lot of different things, and I think, you know, this has been shared with you before. I think maybe in October, I understand that this was communicated, that the Good Otis folks perceived that this was a contract between the city and Otis Good LP. And that it represents a set of obligations for which there was consideration, and the consideration that the Good Otis folks did is they annexed 1,700 acres of property into the city of Raymore. And in return for that, they expect the densities in particular to be respected. And it's our position, I think, just to state for the record, that we do not believe that the city can vitiate the obligations of that MOU without just cause, without our consent, quite frankly. But to move on from that, since the execution of the MOU, it's also important, I think, to recognize, okay, this document was embraced by the city. It was incorporated into the city code. It's incorporated, I think, in more than one place, not only in the reference that you're seeking to change here, but maybe other places. It's a planning document that has guided decisions since the whole last 20 years. And I'll bring up here, and I have to walk away from the mic for just a second, the same map, but this map represents all the tracts that have been platted, and just so you can see, you know, how much development has occurred. And these crosshatch are either final plats or the crosshatch areas represent final plats or preliminary plats that, in the case of final plat, would be recorded, or a preliminary plat to show the layout. And the important part about that is the MOU gave rise to a successful, dynamic, a very successful public-private partnership. And the platted areas, some of which are fully developed out, as you all know, you drive down Lucy Webb, you'll see lots of houses there that have been built over time. And you know, and along the way, some of this green space that's been shown on this map, it was dedicated. I think about approximately 80 acres have been dedicated to date of green space. There's other acreage, I think, that's been dedicated to, some of which has been dedicated to the city, some's been dedicated to the HOA. But the point is, the guiding document has been what we've been following. It was approved, it was embraced as a very valid, very useful document. It was the basis for a public-private partnership that we've been working under, and it worked very well for as far as the development of what is a very large, prominent tract for the city of Raymore. And so far, there's been no concerns that we're aware of or complaints as it relates to downstream issues in the riparian corridor. No concerns really of any nature whatsoever. No citations for erosion control issues. I mean, this is a very responsible development, being developed by a very responsible developer in conjunction with a very productive partnership with the city. But it's not just the Good Otis folks and the city that have been relying upon this document to date. There's a lot of other stakeholders here that have looked at this document not only for guidance, but they've relied upon it to their detriment to understand and make financial decisions. The city of Raymore has relied upon its detriment because the city of Raymore has guaranteed bonds to build the Hubach Road expansion. And that bond issue, although I'm not here to really get into a lot of detail, but what I put together here, and I'll go back to the mic so we can get this on the record. What I put together here for you all is a summary of costs that have been expended in reliance on the MOU. Now, of course, the developer, you know, would be expected to incur costs, and they have. You know, the developer has incurred an approximate amount, as you can see there, approximately $10 million over the last 20 years, but actually more than 11 and a half, because they've contributed to roads. Okay, the placement of those roads were put there in reliance upon the fact that there's densities for housing development and commercial development in the tracts that are around the roads. The placement of the interchange was put there because there was an engineering study done at the time that wanted to open this up so that the commercial development and the other development would be in proximity to the placement of that interchange. But likewise, if you go across the road, there's things you guys probably don't realize. The city of the Cass County has got $3.6 million in reliance upon this MOU to support infrastructure development out here at this area. And in some cases, I think in all the cases, that amount of money is setting in some of the cooperative agreements that have been entered in connection with a number of these infrastructure programs with a right of reimbursement. And so does the Great Plains Group, so does this Graham. Graham is the gentleman that donated the right-of-way on the Belton side of the highway to make way for the interchange project and the outer road, okay? Well, he's sitting there expecting someday, when that TDD produces revenue on the Raymore and Belton side, to have a right of reimbursement from that revenue stream. And so the point I make with this is just, I think this is a fact basis. It's a set of facts that I think, as you all make decisions, and staff tries to make recommendations to you as to what to do, this MOU has been a basis for a lot of business decisions, and it's really kind of hard to unring the bell. Not only do we believe this is a binding document, but more importantly, there's a lot of people that are gonna have to deal with this decision when we deal with the density reduction that we believe will be to follow from the stream buffer ordinance. The stream buffer ordinance before you this evening, really what it does is it eliminates the exception for the Good Ranch. I mean, we're really the primary point of concern tonight. I know that there's 3 MOUs in the city, but I don't know if there's anybody else here to speak to another MOU. And if I'm wrong, please correct me. We have another spokesperson as to the other MOU. And so this MOU concept has been a construct in the city for 20 years now. We're the beneficiary of a 20-year cycle. The other MOU is not so long, but it's still a construct that's very important to the decision making. And this will eliminate that. And so then, and the odd thing about it is, I know in some of the conversations we've had, staff has indicated, well, this ordinance has been in place since 2008. We're just having to comply with an ordinance that's been around for what, 6 years? Well, we had the exemption. We had no reason to object at that time. Now we have a reason to object. Now we are at the table having to deal with what we perceive to be a very excessive a buffer setting, in our opinion, and now we're here to say our piece as it relates to how that would apply to our property. We've looked at some of the regional ordinances. We invited our engineers to come this evening. If it's relevant and desired, they've kind of looked at this and have a perspective. They've worked on stream buffer ordinances across the Midwest. They would have an opinion, you know, how this compares as far as setback distances and the application of how it would work, whether it is on the spectrum, where does it lie? And I think, you know, one of the things is probably now the best to talk about, and like I said, we've looked at regional ordinances. By our quick assessment, and we've had some time to look at this, but we need more, we believe this is probably one of the more stringent, invasive ordinances, your setbacks, of the metropolitan area. Now that just is a statement of fact, a statement of opinion, I guess, really. But I thought I would just share that to you, because we think that there are alternatives that are much less invasive that you should be considering. But again, it may not have an impact on us because we truly believe that the MOU should stay in place and the exemptions should stay. But this is representative of the impact. And so this is here and this is now. The Good Otis Group has a preliminary plat. Actually, when is it slated for consideration by this body? In 2 weeks? March 4th. March 4th. So you have a preliminary plat that you're looking to take action on. And let me go back to the microphone. And so what you're looking at is a map, a blow-up map of the plat that's coming before you. And the gray lines that you'll see there is an overlay of the setbacks based on the stream characterizations that I believe we got from city staff. Is that correct? And so, as you can see, this plat contemplates, this is a commercial frontage of the new road that all of these people that spent this money are relying upon to generate retail income tax to pay them back, including the city of Belton and the city of Raymore and Cass County and so forth. This is the frontage. And so if you go through there and if you just look at these gray lines, and the white lines are what's left based on the buffer system, I mean, you're looking at 10 buildings and we may result in 2. And so when we see that, we're starting to jump up and down here a little bit. Okay, we're starting to say we really need to slow this steamship down. We need to sit down. We need to talk. We need to communicate with staff. And by the way, we met with staff last Thursday. We met with the city attorney. He was there as well. And I'll kind of jump to the chase, but on the other hand, I've got some more information to share with you. We believe what we would like to do, akin to what Dave Otis just indicated, is we're really looking for an opportunity to really understand the mutual impacts of what this does, both economically and ecologically. But economically is really what we're focused on. You know, there's a lot of people relying upon this development to be successful, and that's why I put the chart up on the cost. Everybody's relying upon this commercial development to produce retail sales taxes. You know, I mean, the city's got an annual appropriation number of, I think, $400,000 that it's paying on debt service on a bond right now. If you don't produce retail sales tax out there, or it's inhibited in some way, then that continues without abatement, right? This next map I'm gonna show you, this map, I showed it to you because it's here, it's now, it's a preliminary plat that's on your agenda. If you approve it, we may end up have wasted a lot of our time even approving it. Now, we don't want you to diminish your consideration of it, but I did want to illustrate to you the impact that we've estimated. This next map is really more of a global assessment. You know, raise the helicopter if you may. This pulls it up and looks at all the commercial property on the frontage of 71 Highway. And as you'll see, kind of those little fingers sneaking up in through there, based on the stream classification characterization that, again, we obtained from city staff. And I know that's very preliminary. And I know that we're trying to figure out how to implement, your staff's trying to figure out how to implement and deal with these issues, right? But having said that, taking that at face value, this is what it does over the whole area. Now, let me take you back a second. If you go up on the upper right-hand corner, there are all those areas that are kind of shaded. See the lots and the buildings? Okay, that's all platted.
Right.
So that's exempt. And all that green space, some 80 acres, has already been dedicated. Okay? Then you come down here to North Cass County Expressway hooking into Hubach Road. You go north of that in that red area, that's the commercial space that everybody that's sitting down at the table is expecting to develop out. And with all these little shaded areas, that could be problematic. You go south, the little green finger coming up there, that's the plat that I just showed you. That's what we're talking about. That's the commercial frontage on the south side of North Cass Parkway. And then you can just see, you go down the way there, you've got the brownish area there to the right, that's multifamily. And those are development opportunities that the good Otis folks are looking at right now. So what does this all mean? I mean, this is a nice picture, okay, and I know that we've tried to put that together, but really, what does it really mean, Jim? I mean, if you assess, what kind of density have you lost? I mean, our biggest concern is there's a number of things the MOU does, but one thing it does is it agrees on densities going forward. And this document, this blow-up, represents a summary of representative tracts. Now you'll notice this only represents a summary of lots 1, 2, 9, 10, 12, and 14. Those are the ones that we chose to summarize. 1 and 2, you'll notice, or you could notice earlier, those are commercial tracts. But if you'll see these numbers, we're talking about reductions in density on the retail side of 540,000 square feet from 1,245,000. We're looking at the retail corridor at 143,000 square feet. We're looking at business park density reduction, 19% reduction or 196,000 square feet reduction, and so forth down the line. All total, we're looking at probably an average of, you can see there the numbers, 43%, 48%, 19%, 25, and so forth. And I'm reading in the middle column, estimated reduction in percentage on account of the MOU change, MOU breach, and then lost development capacity, loss in units and square footage. So we're looking at merely on 1, 2, 3, 4, 5, 6 lots. Now granted, there's like 26. Okay, so this is not a complete analysis of the whole Good Ranch. It merely takes into account some of the bullseye properties right there on North Cass Parkway. We're talking about a reduction of a million square feet of productive commercial capacity and nearly 440 units of residential. Well, that kind of walks you through our dilemma. Our dilemma is we've had this exemption. We've tried to be very responsible developers over time. I think everybody here, I don't want to show a raise of hands because inevitably maybe I'm not correct, right? But my understanding is the relationship between the city and the Otis Good developers has been very positive for the whole 20 years. Jim couldn't make it down here, but I know Jim has a lot of ownership in this plant. You know, Jim is very, Jim Otis is very active in the, is it the Illinois Conservancy? I mean, he prides himself, this plan probably had, it actually was probably his creation, and he prided himself that it has a lot of green space. And one of our big questions that we've asked, we met last Thursday, we asked, why is this plan, why are we changing, what's the need for the change? I know that we've read the staff report. The staff report says, well, the MOU doesn't deal with open space. Well, that's wrong, it does. In our opinion, it does, and it was intended to. There's a reference to an oral conversation with the EPA that you really need to think about this stream buffer stuff. Okay, I take that at face value. I don't know if that's a good reason or not, but and we asked some other questions. I'm not trying to beat up staff. I'm just trying to say that there's been a total lack of dialogue, as I understand, from the between the developer and developer's representation and the staff. And I think there needs to be more. I mean, we're here tonight to explain the facts. We obviously may have rights that we could assert later, but really what we're here tonight is we're here tonight to ask you to set this thing over, delay your consideration. We've asked staff to make themselves available so that we can work together to continue this dynamic partnership, this public-private partnership that's worked for 20 years. And let's figure out, A, do we even need to change the plan? What's wrong with this plan? No one's told us that. We met last Thursday, and again, I'm not beating up on staff, but staff said we haven't looked at it. We haven't looked at it that way. Okay, I get that. I'm not beating them up. If there is a need for a change, then we're open to discuss that. If there's a legitimate need to discuss change on this plan, we need certainty. We need to know with this much property what we can do over time. We need to know what these stream, if we have to live by a stream classification, what is a stream classification? I've talked to folks that say there is no such thing as a class 6 stream on this property. Well, if there is, we need to know that. And we need to know that very concretely. And we need an MOU that says that. So we would entertain the possibility, although we want to be justified, that maybe an amendment to the MOU. And then finally, to wrap up, Mr. Chairman, we think that takes time to do. We think that takes involvement, and involvement that, as far as I know, has not occurred. This is a big change, and it's not just a change that is going to impact the developer or the landowners. I hope I've been able to communicate that to you, that this involves a far-reaching set of stakeholders that aren't even here tonight. This involves the city of Raymore directly, as far as your financial situation and some of the financial commitments the city has made. And so, and unless I could hear another reason why there's some urgency, I don't see why the delay couldn't happen. And we just believe in importance to keep this partnership stable, to keep this partnership working the way it's been working for the last 20 years. This delay would be justified. And then for that, we would pledge ourselves to be available as necessary on a very immediate time frame to work with staff, mobilize our engineers and our design help, mobilize other folks in our team that would be needed to have that thorough dialogue and reach those conclusions, which would inevitably, I think, come back with a revision to what's before you tonight at a minimum, if not something more significant than that. But until we talk, we don't know. We don't know. I'd be glad to answer any questions. We have some other folks that might want to comment. David, Gibb?
Right. If you don't mind, while you're at the podium, it's an easy opportunity if commissioners have questions for you right
Glad
now.
to answer any questions.
Otherwise, we'll run you back and forth. We
No
do
worries.
that a lot.
No worries.
So while Mr. Grice is at the podium, do any of the commissioners want to address any questions specifically to him or go on with the public hearing? No? Okay. We'll let you sit down and
All right.
let somebody else come to the podium. Thank you.
Good evening.
Good evening.
My name is David Flick. I live at 17040 Highland Ridge, Village of Loch Lloyd. Cass County is my home. This particular subject we're talking about tonight is my personal and professional area of expertise. I am the principal and founder of Terra Technologies. Our firm handles the federal and state environmental permits that are required to authorize development to move forward. So 30 years of doing this type of work, I can tell you that 250,000 people in Missouri and Kansas live in homes and apartments resulting from permits obtained by our firm. So our area of subject matter expertise is section 401, 402, and 404 of the Clean Water Act. So my statements tonight are purely as an education resource. I counsel and work with about 60 cities here in the Midwest to provide education and guidance in order to help you make the proper decisions that you see as best. Now, some of the conflicts that we hear tonight, we hear across the Midwest. Undeniably, local jurisdictions have an interest in stream buffer setbacks. They are important. They're important because the governing body of law that involves protection of streams and wetlands deals with 2 points within the channel, and that is called the ordinary high water mark. Under federal law, anyone who wants to place fill within the ordinary high water marks of a stream must seek a permit from the federal government. That program is promulgated by the U.S. Army Corps of Engineers, regulatory branch. Enforcement of the program is handled by EPA. Very important concept. Where we get in most trouble with stream buffer ordinances is when we enact regulations at the local level that are in conflict with federal law. Very important to understand the Clean Water Act and the Army Corps and their permit program. For instance, the sole authority to determine when streams can be impacted, when it is justified, when it is practical, is the Army Corps of Engineers. And in certain cases, there will be streams that they demand be impacted because of their rules. And so you have this whole level of federal governance that when we have municipal rules that are important, that we try to make sure are conducive with those. So did you know that there is a very complex permit system where the Corps determines when a stream should be filled in for a shopping center, for a roadway exchange. They determine when it is most practicable, and we have an entire federal section that defines practicability. The federal agency looks at the overarching public benefit of impacts, not just what the benefit is financially to a developer, and they issue an opinion at the end. They will either issue a permit authorizing those impacts, or they will deny a permit authorizing those impacts. So for all of these things for stream buffers, these really deal with jurisdictional water bodies that are not authorized for impact by the Corps. You know, very important concept, that the federal agency can authorize any applicant to fill in channels. Now this is very important from a development community and from a public infrastructure community, because there's times when public safety or density of retail, et cetera, are determined more important than buffers against streams. And that's what the Corps is there for. For instance, if you were to permit a subdivision right now, irregardless of what your stream order map says, the developer is required to go to the Corps and submit a jurisdictional assessment. Where are the locations and extents of jurisdictional waters? The Corps knows local municipalities develop stream order maps as planning tools, but the Corps determines what they're going to have jurisdiction on, and they have jurisdiction on everything. A lot has changed in the federal regulations the last 5 years, and more is going to change. Practically anything that has an eroding ordinary high water mark is now regulated by the Corps. And impacts to their jurisdiction are limited to 300 feet. 300 feet is all you can fill in while getting a nationwide permit. So development today, almost every project requires an individual permit. Now, in the whole process, the Corps not only looks at what their jurisdiction is, but what is the quality of their jurisdiction. And one of the biggest challenges we have in development is that we have impaired waters. The spirit of a stream setback ordinance is to protect water quality. It's provide water quality and protect downstream receiving waters, et cetera. But a lot of our streams today are highly impaired. They're impaired because prairies were changed to fescue. They're impaired because now collection alongside a highway dumps a lot more water. So many times they'll look at a stream and say, that stream's impaired and development is going to further impair that stream. So they will require the developer to go in and make anticipated changes to improve that stream's global stability. You have in front of you a stream buffer ordinance that has many great features. And there's been a lot of hard work in this community. I want to encourage you to take what you have now and consider some of the changes that are in place, but also integrate other improvements to it. For instance, as you read, the current standard under applicability Part D, what does that mean? What does Part D mean when it says, if a development obtains a Federal Clean Water Act individual 404 permitting allowing a stream to be relocated or otherwise altered? Well, 404 individual permit allows alteration of a stream. So does that mean this section doesn't apply? What most municipalities are now doing are revising these agreements, recognizing that if the Corps authorizes impact to a stream, that these buffer ordinances refer to streams that remain at the end. Because the Corps may decide that the road shouldn't cross the stream at a certain angle. They are the highest say in what impacts are put into place, and they actually issue, those permits, and an individual permit is open for public comment and review. And it's a very thorough, complex process. I mean, the Corps is just very good at handling this, and they handle these matters. So in any community, when they issue a jurisdictional determination, they will clearly articulate what is their jurisdiction. And we would encourage you, if the Corps doesn't claim jurisdiction on it, it's my suggestion to you that you don't want to regulate what's left. Because the Corps doesn't claim jurisdiction on it, it's not a stream. It is not a stream. By law, they have to regulate streams that have an ordinary high water mark. What is left are ditches and swales, things that they lack the appropriate jurisdictional standing on. So in this whole concept of your buffer plan, you have a process that if the Corps doesn't claim order on something that you claim is a first or second order stream, then I'd suggest to you that your order map is more of a planning tool. If they're not going to claim jurisdiction on it, and I'll repeat again, they claim jurisdiction on everything today, everything. Then it has either been modified since the delineation, your order was done, or it simply has too small of a watershed, to be a jurisdictional water body in everything. Couple other things for you to consider, just little technical things. Under buffer and stream setback requirements, plan requirements, paragraph C, item 5, referring to APWA's planting plan. I encourage you to add the reference to the Missouri invasive plant species list. Some of the things on APWA's planting plan are under Missouri law, not legal, to be planted in a stream corridor where there's federal jurisdiction in everything. So I think that the biggest part of this is that when you consider as a community that you have this complex federal oversight that helps balance when streams should be impacted, when they should be culverted, etc. When you have that, at the end you have remaining non-impacted jurisdictional water bodies that clearly you want to have some degree of protection and setback. Now, last night I appeared before a governing body. I appear before governing bodies at least 3 nights a week, explaining permits and what they are. And we had a local municipality who had a stream buffer ordinance and said that stream will not be impacted. And the federal government stepped in and said that stream will be impacted, it will be moved as a requirement of our permit. So you had conflicting legal authorities of what happened. What was about was an impaired water, a stream that, remember, a lot of what we call streams today, they weren't here 50 years ago. I was raised here. A lot of the things you see adjacent to our streams weren't here 40 years ago. We didn't have riparian trees on our riparian corridors, et cetera. And a lot of these first and order streams are really a result of us as humankind, how we've used the property. Most first and second order streams result from taking prairie out and putting pasture back in. You know, you can replant over the pasture and prairie, and those first and second order streams will go away because you increase the amount of absorption and everything. I'll repeat again, you have a great framework, and there's been a lot of work done in this community and everything, and I want to encourage you to keep working toward that. Another example under C Design Standards, Article 3. It talks about flood maps and boundaries. Well, how do we as a community deal when a LOMAR? How do we deal when the engineer calculates a new floodplain? You know, because oftentimes that show up on flood insurance maps, they may be zone AE, they may be based off of historical limits, it may not be calculated limits. And this is something city staff's very familiar with, but putting a reference into something like this that, you know, gives you the ability to adjust a stream buffer based off a calculated floodplain limit makes a big difference in everything. So the final thing is that in certain instances, the federal government will step in, and as a requirement of issuing a 404 permit, they will federalize their interest in the land. By federalizing their interest, they are requiring that their conservation easement must be recorded to protect the stream and a stream buffer and everything to be protected through perpetuity. It's a very, very complex process, but we encourage all municipalities that when you are dealing with a federal interest on a property in the city, it is the strictest of conservation easements. It is recorded at a courthouse, and a simple reference in something like this that the federal conservation easement and the buffers associated with it take precedence over a municipal easement. It's very, very important because it's the highest order of protection for a water body is federal interest. It is protected by financial assurances. It is assigned to an independent third party, and it puts violations under protection of the U.S. government for perpetuity, and it puts enforcement of the conservation easement under federal authority and everything. So I know these are very complex issues. I want to say again, I want to compliment city staff, everyone who's participated in this whole effort, and my opinion is, with a few more tweaks into the basic structure, you can have a buffer ordinance that really works and works seamlessly and accomplishes what you want. And at the same time, you can have great confidence that the federal oversight of streams and things is a procedure that looks at, on a watershed by watershed basis, what impacts are justified and evaluates all of those concerns and stuff. Thank you.
Thank you, Mr. Flick. Any questions? I assume you're willing to take questions if the commissioners
I just
wish.
wish there was taco night at City Hall.
Oh, yeah,
Tuesday night tacos is ridiculous.
sorry. Commissioner Burke.
My question for you is, are you suggesting that we delay decision-making on this particular issue until it's been explored further with federal, in regards to federal?
I think it
Or-
would be a benefit to all, the city and to the citizens, to especially make sure that this puts a reference in to the authority of the Corps and, and those decisions on when a stream is impacted or not.
I was just seeking to clarify your position or opinion.
And I'll state again, I'm here tonight, I'm not retained by anyone. My opinion is mine. Now, everyone behind me, including your city, I have worked for over the last 30 years, okay? Most every development that's there, and that's our area of expertise and stuff. But that is my recommendation. It's a recommendation I give to most municipalities is to integrate the federal program and a reference to it into yours, so that it's not you deciding when a stream is taken. That is reserved under federal law to one agency. They decide.
Thank you.
Any questions from other commissioners? Mr. Flick? No? Thank you.
Good evening, my name's Randall Leimer. I'm General Counsel with Great Plains Developments. You're probably accustomed to usually seeing Bob Jackson up here at these times. He's unable to be here tonight. I'm gonna try to fill his very capable shoes and probably won't do a very good job, but, you know, I think we just heard another example of the position that we support also, which is this isn't ready yet. You know, we really need to sit down and discuss this framework that's being proposed right now. We may have different motivations than some of the other folks here for why, but certainly, you know, I guess just to kind of clarify who we are and where we fit in this puzzle, we have a ownership of a portion of the Good Ranch, which is called the Estates and the Villas of the Good Ranch. We have a preliminary plat on that. It's about 136 acres. It's been preliminarily platted for residential, multifamily housing. That preliminary plat was approved before what I guess I'd characterize the Great Recession, some time back. The current version of it expires in less than a year. You're considering some amendments to the code tonight in part that affect how preliminary plats are approved, how they're extended, whether they're extended. We really feel that some of the criteria that are introduced here could interfere with a reasoned and logical approach to why, when, and how something like that should happen. It's almost working to take away some of the discretion, I think, if you kind of drill down into the criteria that they're offering. And what you need is flexibility when it comes to these things. I think if you look at the last 4 or 5 years, we can all look at what's happened economically and understand, you know, this area wasn't ready for development in the last 4 or 5 years. The market spoke. The market said, residential housing isn't happening right now. We have to wait. We have to wait for things to take their course. So when you change something like this and you codify, here's what you have to consider. Here's how it has to be. You know, we just have to be very careful that those criteria make sense, that they don't overly tie your hands, the city council, or anyone else, so that we have the ability to go in on a case-by-case basis and really do the right thing. Many of my other comments have already been discussed tonight, and I want to follow your rule of not reiterating.
I appreciate that. Thank you.
Given the fact that we're on a public record, there are couple of quick points I do want to make. On the MOU, we're under preliminary plat with our property. If it's not extended by the time it expires next year, which is starting to look like it would be a possibility under this new framework, then we fall right back under the Good Ranch MOU. You know, we are squarely in the group of impacted developers who have spent a tremendous amount of money, time, resources, and in reliance on that MOU, what it stands for. We relied on it when we entered into that cooperative agreement for the Hubac Hill TDD, the Transportation Development District. We subjected and agreed to subject our property to taxation for that. We put up more than $440,000 cold hard cash to build roads and infrastructure. We dedicated more than 100,000, we've already put it up, we dedicated the land for the Hubac Hill Road widening and extension. We have a lot of reliance, financial and otherwise, on being able to develop that property the way that it's been planned, the way that the master development and the master plan has been set out. It's just not something you can go back in later and say, gee, I don't like the way that lays anymore, that doesn't work. We do have a framework, a series of stormwater detention ponds on our particular property that literally cascade down the side of the hill. We have a lot of work that's been done. Some of the staff comments, you know, when they said that stormwater runoff wasn't considered, I really don't think were well thought out in that regard, because they really were done. And I think some of the other comments tonight echo that as well. The other impact I think you have to consider is the city has guaranteed all of those bonds. And if you put the cumulative costs together, just on that cubicle TDD over the course of its life, the liability is probably close to $10 million between the interest payments, the sinking fund payments that have to be made, and other funding that has to be made by the city. If this property can't be developed successfully in a way that generates taxes, that allows the city to be repaid, there's a lot of money to be lost on both sides. And this isn't just about money. We all want to be responsible developers. We intend to be responsible. We've been involved, our company has been involved in the city of Raymore for many, many years, over 20 years. You know, we take pride in our record in terms of how we work and the type of work we do, and hopefully the results bear that out. So I guess, you know, from a big picture standpoint, we back the idea of let's slow the process down a little bit. Let's consider all of the criteria. Let's make sure that the engineering and the science behind what we're doing makes sense. Let's make sure the federal government's concerns are addressed and appropriately incorporated. You know, we all want to do the right thing. We don't want to go at it too quickly, and so we're respectfully requesting a continuance on this as well for the time being. Thank you.
Thank you, Mr. Leamer. If you'd like to wait a minute, see if commissioners have any questions. No? Thank you.
Okay, thanks.
I was afraid I was going to have to ask.
Chairman and Commission members, my name is Chad Sayer. I'm with Allstate Consultants. We have offices in Columbia, Missouri, and also Marceline, Missouri. I was raised on a farm in north central Missouri with a lot of cattle and quite a bit of row crops. And my dad was an engineer before me, and my brother is also, and we're partners. And we are lucky enough right now to be working on about 100 miles of jurisdictional stream assessment, supplemental impact or environmental impact statements, the 404B permitting process, mitigation of those properties. And I want to tell you that to have Mr. Flick in your community is a huge asset. He's well known across the country. We've met with him. His resume is unparalleled, and I'm not here to try to parallel that resume. But I do want to tell you that we are active in these processes. Most of our work is done for public bodies, municipalities, other entities, public entities that are constructing projects. So I wanted to let you know that. In this particular case, we're here working with Jim Grice and the good Otis folks.
Thank you.
And we haven't had a lot of time to assess it, but I think a lot of the things that Mr. Flick said are very important. One thing is the federal process is very, very complex. And I would not recommend, after dealing with stream buffer ordinances that were initiated, adopted, revised, and revised, and revised, and revised, and revised, that you try to model after their process. And I don't recommend that you try to depend on them to be prompt with a jurisdictional termination of a stream. And even for a period of time, there was almost 2 years where they wouldn't even issue a final jurisdictional determination. It was just a preliminary JD, and you had to rely on that. And if you're lucky enough that your municipality is sophisticated as yours, they have the staff that can act upon that, then what you really boil this down to is your very first wave of assessment, irregardless of the signed binding MOU that the attorneys are talking about, and about the way that it's impacting the property and potential future claims of impacts and all of these things. That's not where we live. Where we live is the very first wave of what your staff will have to deal with if you, and they have, you're lucky to have a community your size and to have a staff like you have, is what is a stream? What is a stream? What's a cow path? I promised Mr. Good I would say that in front of you guys. What's a cow path? I know what a cow path is. What's a drainage way? What's a swale? How can those be used in the headwaters to really benefit what Mr. Flick, I agree with him again, the primary purpose of what we understand, of what the purpose of this ordinance is water quality and aquatic life. Whenever you start seeing stream buffers, they're called a stream buffer, but they extend over that 100-foot mark. The science behind those and the studies, and we participated in those, and we've looked at a lot of different products, structural and non-structural BMPs, best management practices, and how they actually effectively remove those things that affect aquatic organisms. Once you get above 100 feet, in our opinion, is a general rule, with this type of topography for sure, I think you need to look at the benefit to the public and the reason and the purpose for the ordinance. And so from a commission standpoint, which commissions change and councils change, what concerned us is it doesn't appear that the stream is impaired. It doesn't appear that we have contaminants to us from the database checks that we've done just in a very brief period of time. It doesn't appear that those streams are classified or targeted as a concern for this watershed. And I know Mr. Flick knows more about this than probably anybody in the county for sure, in the whole area. So he can comment on this to staff at a later date. But I think if the purpose is to, I'm a farm boy and I'm going to simplify it for you. Pedigreed farm boy, okay? I believe that you should take a hard look at this and look at the cost to your permitting divisions, the cost to your public, not counting all of the tax revenues and property tax revenues and TDD revenues and CID revenues and NID revenues and all of the things that are yet to come to you, okay? I think you need to look at just the way this language is stated and the permit process that you're trying to model. Really take a hard look at that cost. And if the purpose is to focus on aquatic life, then we think you need to focus on your headwaters, on your smaller streams. That's where we've seen the most benefit, and the science has indicated don't focus on the 300-foot wide buffer on each side of the stream, 2 football fields wide downstream on what somebody's claiming is a 6th order stream. So I'm making these comments to you in this quick public hearing. We believe there's a lot of impacts that you may not understand yet until you fully assess it against a master plan community like the Good Ranch. And whenever we've done this, and we presented it at national conference, it's been 4 years ago, 5 years ago, the impact to a master plan community, it was so significant that the community that was implementing it took a hard step back and said, well, that was not our purpose. And so we think that refinement, that can be done, and we think the Good Ranch is a great example, and probably your other MOU tracks. But I have a couple handouts to let you know, but the Good Ranch is such a significant, so much larger in the amount of land area.
Yeah, please feel free. We can pass. Oh, they're all one, sorry. I was thinking it was.
The last thing I'd like to talk to you about is stream order classification. If we misclassify a stream in the headwaters, it's not a linear impact as you move downstream. And so if we misclassify, or if we call something a jurisdictional stream, a class 1 stream, then when that stream continues to grow and go downstream, and another class 1 stream runs into that from a first order, then it makes a second order stream. So it's not a linear impact. And if you look at the difference in the current proposal in the city ordinance, it's a 300-foot requirement for a 6th order stream, and then it's 185 feet, if I recall, for a 5th order, 140 for a 4th order, 100 feet for a 3rd order, a 2nd order is 90 feet, and a 1st order is 50 feet. From the average, it says a minimum average buffer width. Right. And so I want to make that other point on the record. that we believe, particularly on the Good Ranch, looking at the master plan, which acknowledged drainage ways clear back in 1993, it's a very good master plan, we believe, from a conceptual basis to continue to move forward on. But we feel like the stream order classifications that have been portrayed to our client need to be looked at, because the impacts of those may be actually working against what your purpose actually was, the overall general purpose and need that's there. So I wanted to get those few key points in on the record. I do think that the focus, unless your focus is habitat creation and habitat restoration, which that was mentioned from the staff as one of the purposes, that's not what we really have seen. And I think what you'll find is the need to prove a need to restore habitat on something that already has an MOU and a current master plan that's been approved, and to be able to basically support that through your processes. We haven't seen that that's been very easily done. If there's an impaired stream or a water quality issue, and if we move downstream that 0.6 or 1.6 miles, if I recall, or 1.6 miles downstream, and we start looking at that, or if there's a TMDL, or if there's some contaminant issue, we could understand and you could defend it a lot more. And like I say, most of our work, we work for municipalities also, and counties. And so I guess I'll leave it at that. I just wanted to let you know, we think there's a lot of concerns beyond the signed binding agreement argument, is that what we've learned from just conversations with EPA and EPA saying they want something, if I was an elected official or commission member, I would want to see that it's in writing, that it's a requirement. If it's going to cause us a lot more time and permitting, a lot more cost to the taxpayers to implement. And then ultimately, I appreciated Mr. Grice's concerns about the assumptions of densities that will then feed obligations of the public taxing entities. And I'd be glad to answer any questions if I could.
Thank you, Mr. Sayer. Questions from the commission? No? Thank you. Mr. Good?
Yep, good, 195th Street and Highway 71. I think I'll live within your 3 minutes.
Good. That's even better.
First, regarding your preliminary plat and final plat approval process that you're also thinking about, one thing I think it neglects is the economic conditions of the time. It doesn't matter if you have a final plat approved or how much time goes by, if the economic conditions don't lend themselves to do a final plat and go on with it. The next thing could happen within that time frame. The economic conditions may demand a total different lot plan or housing plan that you never had any idea about, when you submitted it. I think that's something that all of you all really should think about a lot, and I think staff missed that point. On the MOU, personally, as representing the good side, that family and the good Otis, not meaning the Otis side isn't good, but I think not exempting that MOU is a violation of the contract between the city and us. We won't know what that violation consists of until we're completely done. And that's mainly because of densities. And that's been said here before, but that's an important thing. Under this whole plan, the densities were important to help when you give this other property to the city, to the park, to whoever. The densities justify that because you get paid back sometime, you hope, by development in those densities. And that was an important part of it. If it needs to be talked about, It's gotta be talked about. It isn't the city's choice to violate it. It has to be negotiated between us and the city. If the city just does what staff is asking it to do, as far as I'm concerned. And I guess that's what these guys are trying to say in a more complicated way. It's a violation of a contract, as simple as that. We zoned 1,800 and some odd acres. We didn't have to do that. We could have gone through piecemeal. We did it as part of the MOU. That was the first thing we did to validate our MOU. We did it in 1994. I don't think that should be forgotten. Thank you.
Yeah. Thank you, Mr. Good. Any questions? We'll proceed. Hi.
Hi, my name is Pete Opperman. I'm a land planner and landscape architect. I'm the owner of Opperman Land Design over in Olathe. I'm not here representing anybody other than myself tonight,
Wow.
but I have to point out that I do have clients in the room. I have done a lot of work on the Good Ranch. I didn't do the master plan, but I've done most of the site planning down there. I consider myself an environmentalist. I get accused of being a tree hugger on a regular basis. And I am certainly not an expert like Mr. Flick or probably the other engineer gentleman that came after. I didn't catch his name. But I have been doing site planning and dealing with streams and trying to save trees and so forth for 30 years. And I happen to be on the committee that created the Overland Park, Kansas stream buffer ordinance. And I deal with, other stream buffer ordinances, and I have to say, from a standpoint of, well, being on that committee in Overland Park, there was like 25 members, and many of them were professional engineers. There were some developers there were real estate agents there were people opposed and for on both sides. But we went through a long period of time. I know it was over a year. It might have been close to 2 years in trying to figure out how, first of all, you determine to protect your streams. And you got to come up with a legitimate basis of where do you start. And what they ended up with, and this, many, like as I said, many of these members were professional engineers, members of the APWA. And I also should say that Overland Park is one of those cities that is big enough, and they have all of this professional staff, and they hire consultants all the time and study the heck out of everything. What they came up with is you do it on an acreage basis. When you get to a certain, 25-acre watershed, I think is where they start, then you have to have a setback of like 15 feet from, and it has to be a defined, as Mr. Flick said, have a high water mark. But even they came to realize, and again, through all these professionals studying for a long time, that you can't take every 40 acres or every little place that has a high water mark and save it, or everything's just too cut up and you don't end up with enough land left to do anything with. In overlaying the streamway system, or the map that you guys have, and I did it because I'm personally familiar with the Good Ranch, the first, especially the first, but I think some second order streams, they're in the middle of a hillside where there's no indication that there's any type of even a rivulet, because all the contours are just going straight across the hill, yet here's an order stream being projected on that hill. In the city of Overland Park, what they decided, and as I said, many other, like Johnson County, Kansas, has pretty much modeled their stream ordinance after Overland Park. So Olathe has also. They allow you because you have to still allow development. There's other ways to protect the streams other than just saying, okay, this little swale has to stay here. You do water quality measures, for instance, where you get the water to soak back into the ground instead of throwing it in a pipe and piping it to the stream and dumping it and not worrying about what was in it. But basically, they're first and second order streams. I think it's up to 40 acres. You don't have to keep them. You can incorporate them into your development through either water quality measures and sometimes underground piping and so forth. But even up to 40 acres, their setback is only like, I believe, 60 feet or 30 feet from the stream. And that's the high water mark on both sides. Your first order streams are 50 foot wide. And another thing that, you know, I think needs some more study is it says in your ordinance that you can impact or you can change first or second order streams, but you have to replace that you have to replace them. I'd kind of like to know how you don't just create streams or replace that value downstream. I mean, so you could go in and create places where there's erosion taking place and you try to fix that maybe, if that's what it means, I'm not sure. But anyway, from the background that I have and the experience I have in doing this kind of stuff, I think that this stream ordinance, as it is much too excessive. And like, for instance, when you get to the bottom of the stream, or where the stream, before it goes underneath the highway at the south end of the Good Ranch, it's saying that you should be set back from the center of that stream 300 feet in both directions. So you can't do anything in any of that area for a long ways upstream because they consider it a sixth order stream, which I think might be kind of stretching the what's a first, second order, third order stream also. I have been looking and haven't been able to find yet what the actual methodology is or was that created all those lines on the map that you have today. And I would actually kind of question who did the stream study. It's an architectural firm that, you know, doesn't have the type of gentleman, the other two gentlemen that got up and spoke here tonight. And I just not sure the proper expertise was there to create your stream water buffers ordinance. And I have a feeling it was actually somewhat arbitrary and needs to be studied much closer. So I would certainly recommend that you not, you know, pass the ordinance tonight and that everybody get the opportunity to study that further. Thank you.
Yeah, thank you, Mr. Opperman. Yeah, thank you. Any questions from commission? No, thank you, sir.
Thank you.
Good evening, Mr. LaRussa.
Good evening. My name is Bob LaRussa. I live at 1102 Southwind Drive. I've been a resident of Raymore for almost 40 years. I feel compelled to vary a little bit from what I had prepared to state because I've listened to several comments, and I just wanted to clarify. It was my understanding that what was before this group this evening to debate or decide on were the changes to the stream setback ordinance as proposed by the city staff, not to debate the value of what's already been passed. Just
Interesting.
thought I would question that. As a Raymore resident and a founding member of the South Grand River Watershed Alliance, I just had a couple of comments that I wanted to share with you this evening. I attended both of the work sessions where the grandfathering of the stream buffer ordinance was discussed. In both sessions, the prospect of removing the exclusion from both MOUs and preliminary plats was presented. I wholly support the removal of the exclusion from MOUs, but am very disappointed that the preliminary plats continue to be excluded. In reference to section 455.040A 6 and 7, the proposed addition to section 455.040 provides an option to eliminate a first or second order stream within a preliminary plat. First and second order streams provide critical functions within the watershed. Even if you disregard the fact that they filter silt and contaminants and recharge the groundwater, they are the most efficient and economical means of controlling stormwater. Additionally, if you eliminate a first or second order stream, depending on how the elimination is accomplished, you risk during a stormwater event backing the water into that stream onto adjacent properties where the stream has not been eliminated, and or the water in the stream on the adjacent properties will seek a new path across the platted development, causing erosion and property damage. When Raymore applied for its MS4 operating permit in 2008, in addition to expressing concern about the amount of land which was being exempted from the stream buffer ordinance, the Department of Natural Resources also stated that there appears to be no apparent protection of first and second order streams. If they had concerns then, how will they look upon an ordinance which specifically authorizes the removal of first or second order streams? My final comment concerns the proposed change to 470.1109C, extension of preliminary plat. The proposed change reads, the City Council shall consider the following factors in its deliberation to determine if an extension should be granted. I propose that the change should read, no extension of a preliminary plat will be granted if there have been any changes in the city code since the preliminary plat was initially approved, and that would impact the development of the property. If this wording is not changed, the first request for a preliminary plat extension for a development which would be impacted by changes in the city code that comes before the City Council after these changes are enacted will set the precedent. If that extension is granted, no other request for extension of a preliminary plat for a development which would be impacted by changes to the city code could be denied. There is no stated or implied guarantee that a preliminary plat will be extended. Therefore, I respectfully submit that the City Council should never extend a preliminary plat for a development which would be impacted by changes to the city codes, and that the number of extensions, if granted, should be limited. Thank you.
Thank you, Mr. LaRussa. Mrs. LaRussa.
Hello,
Hi.
my name is Sharon LaRussa, and I live in 1102 Southwind Drive, and I've been there for over 40 years. I'm a current and founding member of the South Grand River Watershed Alliance, so I'm familiar with Raymore after living here for many years, and its stream system, and how Raymore, with its elevation, is at the top of the South Grand River Watershed that ends at Truman Lake. There's over 2,046 square miles in our watershed, and Raymore is at the very top of that. So if you think of a little teacup, Raymore's out on the top edge, and everything that happens in Raymore feeds down. And that's why it is so important that Raymore is so aware of what they do to their streams and how they treat them, because whatever happens in Raymore happens downstream. Most first and second order streams in Raymore are called prairie streams, because the way that Raymore was way back when, which are intermittent and shallow, sometimes erroneously referred to as a ditch, and the water flow spreads out during rain events, as opposed to the higher order streams that have deeper stream beds. And these streams, by the way that they function, allow water to infiltrate into the ground while filtering out pollutants, and they function as an excellent means of stormwater control that doesn't have to be engineered to function. It functions naturally. First and second order streams are the foundation to the whole stream system. Over 75% of all streams are first and second order. If filled in, the water that would have been contained within these streams will seek a path to get to the higher order stream. The new path that is formed will cause erosion that will have to be dealt with, most likely by the city. The filling in of streams was allowed in the past, and the city has had to pay for rehabilitation in these areas. Therefore, I believe that the proposed wording regarding the possibility of eliminating first and second order streams should be omitted, whether they are under the purview of the Corps of Engineers or not. As the municipalities are currently required to mimic pre-construction runoff quality in all new development projects, I don't see how allowing first and second order stream elimination will help them meet this requirement either. The streams in place are already functioning, so why re-engineer and reconstruct a function that already works and is natural? In addition, the proposed change to the UDC lists the factors to be considered when a preliminary plat extension request comes forward for consideration by the City Council. I suggest that an additional clarification be added that states if an extension is granted, only a one-year extension can be granted and the preliminary plat will expire unless a final plat application is submitted prior to the expiration date in accordance with section 470.130. If the preliminary plat approval expires, the preliminary plat must be resubmitted as if no such plat had ever been approved. And just as a little side note, we own property in Raymore and we have both first and second order streams on that. So I've taken the level 2 water quality assessment and I am certified as level 2 water tester. So I'm familiar with the streams, and to negate first and second order streams would be a very hard thing to accept. So thank you very much.
Yep. Thank you, Mrs. LaRussa. Would anyone else from the public like to speak? So, Mr. Willard? Hi.
Sir?
Yeah, sorry to break your concentration. At this point, I think I would normally close the public hearing, open discussion among the commission. What's your advice on that?
Well, I would suggest staff indicate whether or not they wish to comment at this time on the many points raised by the numerous people here. But in light of several requests which have made, I don't believe there was any opposition from a staff to a continuance of this public hearing to a date certain. Certainly the commission can ask any questions of staff at this point they want, but I would not recommend closing the public hearing at this point.
Thank you, sir. Appreciate that. So if it's all right with commissioners, I'll turn the floor back to Mr. Cataract for a bit. Is that okay? Are you? Yeah, and see if
I don't think he wants to.
your assignment, should you choose to accept, city staff, feel free to pass.
Well, I'll start.
to,
I don't
Mr.
have any
Krass as well.
specific
Yeah.
comments to make at this time. Certainly, Mike Krass and myself are both available for questions. If you have questions specifically on the comments, there was a lot of comments made. We took
Right.
a lot of dubious notes on that. And
Well, I guess what I'd ask you rather pointedly is, at this point, is there anything that you would particularly want to amend on staff recommendation, or shall we proceed with discussion among the commission?
like at this point, proceed with discussion.
Yeah. All right. Thank you. Appreciate that. So with the note that the public hearing is still open, I have not closed it. However, I don't really want members of the public running forward randomly. We may certainly ask additional questions and call you back to the podium if we have specific questions, I think. And with that, commissioners, any particular questions or topics of discussion right now? Oh. So the public hearing is still open, and we have not heard from you, I don't believe. But if it's okay with commission, please come forward.
I have a specific question.
Now, Okay, may I have your name and address
Sam.
for the record?
Sam Fiorella, 944 Selby Court.
Sure.
Raymore. This isn't on the water issue, but it's on the development. I brought up the picture of it online, and it showed that Fox Ridge was going to be cut through if and when they do this development. And
Fox Ridge Drive. Okay.
Fox Ridge Drive.
Yeah.
The only problem, the way I was looking at it, it showed Fox Ridge between Dean and 71 Highway, which I didn't understand looking at it, because Fox Ridge is actually the other side of Dean, but it showed it between Dean and 71.
Right,
Maybe
unless
that's
they
been-
cross
maybe
over,
that's
and
been
I'm not.
cleared up, or
I'm
I
not
don't see
sure.
how that can be over on that side. If it's actually gonna be cut through, it wouldn't be between Dean and 71 Highway.
Right. Good question. I think unless Mr. Catarat or Mr.
just
Krass want to try to address it now, I don't know that I have enough detail on the map. Do you want to address that question now? Mr. Good? Okay, so this is back in the early map then? Is this back in the early map? Yeah, I'm okay for the minute. Okay. I think any further questions on this? I don't know, I don't really feel that question specifically is going to influence our decision this evening, so I think if you don't mind, I'd recommend give Mr. Catarat a call, and you can discuss that. Is that okay?
My only concern was additional traffic as a resident.
Right.
With the only street going through right now being Haystack.
Sure.
My concern was another open street would help.
Right.
But
I
being
understand the
being it was
concern.
placed on the other side, I
Right.
just didn't understand what I
No.
was looking at.
I understand the concern. I don't think that it actually is relevant to this particular case on stream buffers, but I
Right.
certainly would encourage you to give city staff a call and get your
Okay.
question clarified.
All right.
Yeah, thank you.
You bet.
Okay, Commission. Always a good place to start and say, does anyone have any questions about what we've heard this evening? Lacking that, would any of the commissioners care to make a motion on case 14003?
Mr. Chairman, I do
Mayor
have a
Kirkhoff?
question for city staff.
Of course.
Mr. Catarat, we've heard a lot of input tonight and I saw you writing a lot of things down. How much time will staff need to investigate this sort of thing?
There were a lot of comments made tonight by a lot of individuals, a lot of information shared. I would, I think from staff standpoint, you're looking at least a month of opportunities to be able to discuss further with the development community, for us to be able to talk to other experts and gather additional information. So if the commission was going to consider continuance, continuing the public hearing to a date certain, I would put that at least to your second meeting in March, at least.
I agree.
That would be March 18th. April 1st would be your next meeting after that.
Yeah. Good question, thank you. Thank you, Mr. Carteret.
Mr. Chairman, I have a question.
Yeah, Commissioner Burke.
Mr. Carteret, is the issue that we're working on tonight, would it take precedence over future business that we would not be able to work on some of the things that are in the planning pipeline at this point that are set for future meetings until we can conclude this discussion? Does that make sense, or is that not germane to how we run things?
It's certainly, I mean, it takes some precedence because of its importance overall, obviously importance to the property owners, importance to the city. I don't think it keeps us from working on the other items that are in the planning pipeline. We have a number of things that we, currently work on, but it certainly will rise to a level that we'll spend a lot of time on it over the next month, and that's okay. We can accommodate that and work on some other items that you're aware of that we're working on.
Okay, thank you.
Mr. Chairman?
Yes, Mayor
In the
Kirkland.
packet, and thank you for asking the question, because I seem to remember that there was nothing scheduled for the March 18th meeting, right?
That is correct. yes,
That's
sir.
what the packet had said, so we're not pushing anything out of the way.
And it certainly isn't unusual of us to have multiple cases running at once now. I will say business has certainly been a lot slower since 2008, as was noted this evening, but, that's certainly not unusual.
To clarify my question, Mr. Carteret, does it impact the March 4th meeting?
No, sir. It
Okay.
will not. We certainly don't want to have it that night. I would recommend keeping them separate because we have, a couple of cases on March 4th, but there is nothing currently scheduled for March 18th, nor would we have any public hearings scheduled for that date,
Right.
since we passed the filing deadline.
Okay, thank you.
Those things set for March 4th will be considered independent of this. This could not be in effect for those, so they'll be governed under the current code provisions for, if there was a preliminary plat, Jim, or whatever was on for the 4th, and that
Right.
will be heard by you under your current code provisions.
Yeah, true. Thank you.
Mr. Chairman. Mr.
Commissioner
Carteret,
Crane?
Prior to that meeting, could we get some reports from, on both the dialogue that you're going to have with developers and also from people like Mr. Flicks, I believe it was, and I'm not an engineer, I'm an ex-CFO, I'm just a money guy. So I, other than the fact that, I've gone out and walked some of this and kind of scratched my head as to where the streams are, but I come from a farming and ranching family, and I understand the need for the protection of these things, but I don't have a lot of background in it. So I'd like to get, I've read up some on it, but it's these guys that know about it, we've heard some tonight, and I'd like to hear a little bit more on that.
Yes, Commissioner Anderson.
This is more of a comment here. I've heard both sides of the issue, and I think somewhere in the middle is some opportunity here. Kind of looking at the UDC, and looking at the MOU, I think it's kind of broad. I guess a personal recommendation would be something to consider is maybe a grandfather provision within the UDC, which kinds, grandfathers as far as developments that's in plan, master plan, community, et cetera. I was kind of writing some notes down here, so I think it'd be a lot easier that, instead of revoking what's been in place for quite a while, that we can put some type of clause or provision in the UDC to account for those that's already in place, and then have a plan in place, for, applicants going forward. So just a thought.
Mhm. Thank you, Commissioner Anderson. So I guess I'd like to just throw my 2 cents in, Mr. Carteret, give you a chance to catch up. I guess you know, at first glance, trying to sift through some high points of what I've heard this evening, it seems like one of the drivers for this case in the first place was Missouri, and I'm going to forget whether it was DNR or I think, but at any rate, forgive me if I'm calling them the wrong thing, but basically Raymore's gotten fussed at by the state for grandfathering too much land, not having enough teeth in our stream buffer ordinances. So that to me sort of seems like some weight over on one side of the scales. On the other side of the scales, and it's really not just a two sides of an argument, but certainly we've heard a lot about the importance of first and second order streams on water quality. We've heard, I believe, from Mr. Flick, I felt like I was hearing kind of the opposite in terms of what the feds regulate, and I'm still, I probably need to reread my notes and get a little more info on that to digest it. But, you know, I think it would be very important, very helpful for the commission to agree with what Commissioner Crane said. I think at a high level, we probably could take a step back, figure out why we went into the swamp in the first place. And you know the humor that I'm referring to there. It's hard to remember why you went in when something. And so I think it would probably be good to reboot, figure out exactly what our objective is, and then try to organize the information that we've received this evening with maybe a path forward to clarify and get additional details where appropriate. Clearly, my impression this evening is this is absolutely not a simple subject. It seems to have a lot of different dimensions. It's not a one or the other. It seems way more complicated than that. That's just my opinion.
Mr. Chairman,
Commissioner Crane?
one other question, Jim. Did DNR get on us because we just carte blanche in total had too high of a percentage of the land? Or did they actually look at it and say, what you have done, we have problems with in specific instances? Could it be that 90% of what we did has no problem and only 10% concerns them? And you know, some of the comments that were made, have we gone overboard?
I think this stems from the fact that under our stormwater discharge permit, we are required to provide and protect riparian corridors in new development. Now, the way they define new development is anything that disturbs over 1 acre. Clearly, when we did this, when we first drafted the ordinance and looked at model ordinances, you know, from the area and across the country, there are certain levels, as we indicated, that preliminary plats, and a lot of them contained information regarding preliminary plats and final plats as the stream buffer ordinance does not impact those. I think, yes, when you start looking at the areas of the MOUs, and when there's over 1,700 acres that has been exempted from the requirements of doing any, you know, as it's written, without doing anything to address water quality impacts from post-construction, yes, they felt we were being too liberal with our exemptions.
And we've followed up on this layout that we've had of the streams, because like I said, I've walked that area up there where Doc's place is and everything else. And I know there, on the map, there was one stream there. And you know, I've lived there for 30 years, and I know that more water runs down the path my horses have walked to the back of my pasture fence than runs through that stream that's marked on the map. So when was that last done? When?
Well, I think what the ordinance contemplates is that, as Mr. Flick, the stream order map is kind of a planning level document. As the developers come in and do more detailed design, there is more detailed information, and there are some instances where, based on more detailed information from the property, a stream order may change. Floodplain, just like with floodplain maps, as they do more detailed hydrology, the floodplain limits change, and so there is some room for refinement within the stream setback ordinance. It's not saying that those are the exact location of the streams, or looking at topography, that's where they fell. So there is some further refinement that has to be done as part of the development process.
Okay.
Right. Further questions? Commissioner Crane?
Hi. Is Mr. Good wanting to ask a question or something?
Oh, I suspect. Mr. Good, we do have a hard time hearing you. Do you mind coming up to the podium?
One of my concerns, and I think these questions reflect it, in the future is who interprets what a 1, 2, 3 order stream is. You have to remember our history with the city. For the first several years, 10 or 12, we had several different city administrators, several different city engineers, several different zoning directors, several different mayors. Sometimes that would change in a 2-year time. If for some political reason that happens again, we're subject to somebody's interpretation that we have no idea who that is or what their definition is. What we would like to do is figure out and do that under our memorandum, negotiate what that is so we can both live with it. We get our people to talk to your people. We try to define those things so we all know where we are in the future. If you change the thing, the MOU, and we don't quarrel with that, what's to keep the city from changing the MOU in the future in any way they want to? We can't let a precedent start. We have to defend our position. Thank you.
Yeah, thank you. And I'm trying to remember, I don't,
David Flick.
oh, you're back.
Mr.
Yes.
Krass articulated very clearly where the motivation is. You might be surprised to know, as a governing body, that all of these requirements are being pushed through the NPDES program at the state of Missouri. That's where your MS4 requirement comes from. But did you know the state has its own separate water quality program? It has the Water Pollution Control Branch at Missouri DNR. It issues 401 certifications to every development project in Missouri. It has tried for years to institute, through its own water quality program, buffers and setbacks, but it has not been successful establishing statutory authorities over it, because waters are the state and their authority is limited between the ordinary high water mark. So what we have across all of our municipalities is, because the 401 program has not been able to establish legal standing, then we pressure municipalities to do this through enhanced MS4 inspections. In every community that we have in the state, as you get up to this, they have these things that they ask, sometimes with great pressure, that you do in everything. So we would just remind the state that they have the authority on a project by project basis. The state issues a permit to every project Every development project that impacts 1 square inch of jurisdictional waters, the state issues a water quality certification. It is known as the 401 permit, and they may condition at that time anything special and unique for your project. It's because of their rules that we now have to put culverts 6 inches underground in order to maintain substrate bases. It's because of those rules that we cannot impact at road crossings beyond 50 feet upstream and downstream. Those are the water quality certifications that are issued by region to the whole state that we all must follow. So staff is correct. They are getting pressure to do these things. Unfortunately, you know, the state has the authority through other programs, and why they focus this on communities this way, we don't understand. We don't, but they continue to do so.
Well, I did note in your prior testimony, I did note the phrase conflicting legal authorities, and I think you've just reinforced that statement.
Right. Thank you.
If I may, is it real quick, because my pen has died and I'm about to call a recess. Go ahead.
Chad Sayer with Allstate Consultants. I believe that if MDNR's staff, and I'd like to know the names of those folks, and the EPA staff that have been mentioned, would see this master plan that was developed in 1993 and 4 by this Mr. Goods consultants, and also the other work that's been done by the fellow that's here this evening, I believe whenever they see that up front, day one, they proposed 392 acres of open space, not counting landscaping requirements that are caused by your other ordinances, say 15 or 20% minimum on each site, and itemize the 148 acres of right-of-ways. I believe that the folks at the Department of Natural Resources, if they actually saw the master plan that was also included in the MOU, which was stated was their concern that it was exempt, I believe they would appreciate the fact that in 1993 they had the foresight to set aside over 30% of open space and right-of-ways. So whenever you start picking on these MOUs, I do most of my work for municipalities, recall. I think if they saw a plan like this that was associated with an MOU that the city was obligated to enforce, I think that they would be impressed.
I would not presume to second guess a government official, but I appreciate your position, Mr. Sayer. Mr. Otis, I am that far away from a recess. Will it be very short?
I just wanted to point out that the man that created that master plan he's done a lot of developments that really take into account conservation. He was the chairman for the Illinois Nature Conservancy. He also did a development in Colorado where it was 1,500 acres, and over a third of that, no, over a half of that was dedicated to a wildlife refuge. So he has a very strong mind for conservation.
Thank you. Unless any of the commissioners object, I'd like to take just a short, maybe 5 minutes, and please don't keep the meeting going in the restroom. And we can reconvene. 5 minutes if it works.
I'm sorry.
No,
Did I hinder you?
Something got locked up.
I thought you had something. That was a long 5 minutes.
I'm sorry. I couldn't get out of the river. I got a bowl of ice cream waiting. Let's go back. guys.
With that emergency, I didn't have time to read it good, but that's what that was. That I get emergency alerts and stuff on.
If we can get everybody's attention and reconvene.
So I was wondering what it was.
Mr. Willerth, a question, sir, about parliamentary procedure. Just a reminder I need. If commission, for instance, were to table a case, then that's more or less indefinite until subsequent motion to bring it back off the table. Am I correct so far?
Yes.
And a motion to continue, is that necessarily including a specific time?
I'd recommended to this matter that there be a motion to continue both this case and the public hearing to a date certain of March 18th or
Right, I think we had,
first, the pleasure of the commission.
yeah,
I think you've heard a complex presentation, both legally and engineering-wise, and it would be unproductive for the staff to come back and try to point various factors out, and would be far more productive to let us have review and dialogue with some of the parties here tonight and get that material to you in a better form at the next meeting, and to try to meet
Right.
someone who was either Commissioner
so I
Anderson
think it
or
was
Mr.
Mayor
Burke.
Kirchhoff's question to Mr.
Yeah.
Carteret about how long would staff need to adequately research. Mr. Carteret's response, I believe, was a month would be good, and that would put us out at either our March 18th or our April 1st meeting. I'm really wondering, would a motion to continue need to specify one or the other of those as to continue to that date, that meeting?
Yeah, I think that's a good idea,
Yeah.
because we're continuing the public hearing also.
Yeah, so,
Republish should be good for dates.
so should we decide to go that way, we might want to have a little further discussion with staff over the two choices, potential choices. Yeah, thank you, Mr. Willard. So meeting is reconvened, public hearing actually is still open, that's a little unusual, but we heard some additional testimony. I think it would be good if commission kind of started at the very high level, quick review, for instance, of what are our options this evening. And I don't know if I really need to go back over all of those in detail. Typically, we would either have a motion to recommend approval or recommend denial, or we'd gridlock, which probably, well, I don't know, would that happen tonight with 7 voting? In this case, we've also had several interested parties request continuance. Had some discussion about that. So to me, those would be our options. We can dig deeper this evening, but I think it might be prudent, given the volume of testimony. Obviously, we've aroused a lot of interest. Maybe that was a good purpose this evening, but I think if we choose to continue this case and give staff time for further research, it would probably behoove us to make sure that we have all of our questions on the table, and if we have any priorities going forward, to make sure that we give staff some guidance as to specific areas that we're interested in for further research. Beyond that, how do the other commissioners feel? Yeah.
Mr. Chairman, I move that we continue this case and the public hearing until March 18th.
Okay, do I hear a second?
I'll second.
All right, so we have something we can work on. Motion by Commissioner Crane, second.
State the case number.
Oh, I will. I can restate, or Commissioner Crane, whichever.
Want me to restate it, or can you just add
I think
case
it's okay.
14003?
Let me just restate it. We only have one case on the agenda this evening, so I don't see any ambiguity. So motion by Commissioner Crane, second by Commissioner Meiske, to continue case 14003, UDC Amendment 19, stream buffers, and the associated public hearing to our March 18th meeting. Did that sound like the correct restatement of the motion? And I guess before we take a vote on that, I'll ask a question again for discussion. We can always amend the motion or pull it back and move again. So just to double check with you, Mr. Catarat, we had a couple of options we were talking about. March 18th just gives you a month even. The other option would have been April 1st. Do you have any real strong concerns about continuing the case to March 18th?
I think, again, March 18th was the minimum amount of time that we would want. We don't have any cases scheduled for that evening. So
Right.
we know that the commission's agenda would be focused entirely on the subject matter.
Right. Do we need to public notice the hearings again?
We will not, since we are
Okay.
keeping the public hearing open.
All right.
We wait till the date's certain.
Good. So no deadlines on that.
If you go to the April 1st agenda, which does give 2 additional weeks, the only unknown factor is there may be other cases on the agenda as well.
Right.
So this will come up first.
Yeah. Sounds like you're okay with March 18th.
I think March 18th gives us, again, the minimum amount of time.
Yeah.
So I think it's doable.
Commissioner Crane?
Jim, I kind of worry your use of the word minimum.
I was too. That's why I put him on the spot.
I mean, this is so complex, I don't think we can do a rush job on it. And I mean, if we have to, I mean, if we, put it out 2 months.
Well, realizing obviously if we can continue the case this evening, if we get into the case again on March 18th and dig the hole deeper and keep shoveling, we can,
Continue it again.
that's always an option. We can continue again. So I don't feel
Okay.
like we're
I have no problem
necessarily
with that.
trapped. I was mainly concerned with Mr. Cataret's opinion of whether that was indeed adequate time. I just wanted to ask the question again.
I just want us to take our best shot at it.
Well, sure.
Mr. Chairman,
Commissioner Burke?
I know that I will not be able to attend on the 18th. I know that hopefully you can still have a quorum and continue the good work.
Right. And we have 2 commissioners absent this evening who conceivably will pick up the case in midstream on the 18th. So that's probably not perfect, but then it seldom ever is.
Mr. Chair?
Yes,
Just to be
Commissioner
clear,
Anderson.
what are we expecting in the 30 days from city staff?
That's a very good question, and that's part of what I wanted to include in our recommendations to staff. I think one of the things that we heard this evening was certainly a willingness on the part of the various interested parties to spend some time face-to-face with city staff, actually talk this through further. Mr. Catarat, I won't put you on the spot and ask you how helpful you think that'll be, but I think definitely there's been an awful lot of testimony has come out this evening. Certainly a lot for us to think about. I think now one of the challenges is trying to organize that and specifically identify those areas of interest. There was a point made, and I apologize, I don't quite remember now who made it. It's probably in my notes, but there was a point made, thought it was a very good point, that the case we were considering was not, in fact, a new stream buffer ordinance. It was a revision to an existing ordinance that's been in place for some years now. And I thought that was a very good point. I mean, to be candid with you, it's easy for us to lose our focus in a long discussion. So I think it's definitely an opportunity, and it's definitely important to us to go back and reaffirm what is the question. Why did we go into the swamp? What are we trying to achieve? And start there.
Far from us would be a response to the point that has been raised that the current ordinance or proposed ordinance is a breach or abrogation of the entire existing MOU, and we will respond to that, whether it legally is or is just a modification. And so options are, we may be proposing a modification of the ordinance on the MOU language, or an alternative to modify these MOUs to take it out of this. So in your grandfather concept, Mr. Anderson, that's something from my side legally be looking at. Engineering-wise, you have heard representations that the master plan as engineering has stream setback requirements or calculation within it, or qualification, and we had represented to you it did not, and so there's going to need to be engineering meeting about that, and then the implementation of how it will work. I don't think there's been sufficient dialogue or meeting between the parties for the applicants or the affected developers to understand what exactly is the affected amounts of stream setback and land in their projects, and so those meetings would be helpful on that, so that hopefully when we would come back before you in the next setting, if there's agreement between the parties, or at least the issues would be clarified or agreements reached as to those three areas, or better input for you, instead of where tonight it would be more confrontational. I hope at that point it would be more cooperative or more understanding of how this is proposed, and whether it's just a modification or whether it's really an abrogation of any existing rights or agreements.
Right, and I appreciate that, Mr. Wellerth. I think Commission's objective many times is to find a win-win, come to some consensus, and while that's not always possible, I think that still is our goal. And if additional time helps that, I don't want to go too far deep, but Mr. Grice, if you'd like to come up to the podium so we can hear you, the public hearing is indeed still open.
Yeah, just one small clarification. So I heard the comment as well that the whole ordinance is not really up for reconsideration tonight, but our position, which I hopefully tried to articulate earlier, but just to reaffirm, I mean, from our standpoint, the whole ordinance is up for reconsideration if we're going to eliminate the exemption from the MOU. Because we've never had standing to really complain about the ordinance, because we've been subject to an exemption, which is
Right.
encapsulated in the MOU. So I mean, it is kind of an option A, option B. If the purview of the city is we're going to wipe out the exemption, well, then our position is the ordinance is excessive, overreaching, and the 300 and 185 in its full format needs to be reconsidered significantly. And we're prepared to bring resources to the table to work with the city to find out a framework. You heard some testimony from Mr. Offerman about, runoff capacity and
Right.
other things that
Let's not, if I may, let's not go back through all of that right now, but
our position,
yeah,
if we still
I do
follow
see your
the
point.
exemption format, which is not currently what's proposed tonight.
Right.
Then now we have to take a position that we think the ordinance, as applied, without the MOU
Yeah.
protection, is unreasonable.
Okay, and staff understands that, and I do appreciate you reminding us of that. I know you said that earlier, probably have it in my notes, but as I said, it's real easy after a while to sort of lose focus. It all starts to blur. It's like shopping for houses after the fifth or so that you look at in a day, you totally forget which one had which. At least I do. So, commissioners, this is our chance to provide any other questions, any concerns to staff to be addressed in a month. Anything you want to add?
Well, I think I said I'd like to have, kind of a summary of the dialogues you have with the developers.
Right.
I'd kind of like to get pro and con on the sides that, well, just based on the last comments, this all goes back to the MOU. And whether I would want more information would depend on what you come up with on that.
Well, and it sounds a little to me like a good neighbor meeting. It's a little different, but it's not entirely different from the concept of a good neighbor meeting and bringing back, and I would note, this is pretty familiar to the commissioners, but we do depend on city staff to do the legwork, and a lot of our research is based on what they've learned and provided to us and their expertise as professionals.
Mr. Chairman,
Yeah, Commissioner Burke.
would I be able to ask of the staff if it would be possible to have, and I'm looking at this, not looking at the MOU, but the actual ordinance, how it relates to, or how it would compare to what the U.S. Army Corps of Engineers suggests, since if we are under those federal constraints, is that something that would it help guide us to be doing what's considered to be under the law in a federal situation, or does that not necessarily apply at a local level? And that's something that I could be educated about with staff, by staff as well.
Yeah, I've included what you're asking for in the list of information that we would provide back to you.
Great.
Going back to Commissioner Crane's comments and other comments that have been made tonight, that, yeah, we would try to address that information and provide that for you.
Great.
Thank you.
Any further discussion on the motion to continue case 14003? I'm getting tongue-tied. And seeing none, let's take a vote on it. So the motion on the floor by Commissioner Crane, second by Commissioner Meiske, was to continue case 14003, UDC Amendment 19 stream buffers and the associated public hearing to our March 18th regular meeting to allow staff additional time to research and additional dialogue with, sounds like, I'm just going to say, all the interested parties, whoever wants to make an appointment and meet with staff. How's that sound? And all those in favor of that motion to continue, raise a hand, please. And amazing, it's unanimous, 7 in favor, none opposed, no abstentions. So we will pick this up in about a month. And thank you all very much. And we will continue our meeting this evening then, Mr. Willerth, with the City Council report.
Great to be back before the Planning Commission, and I brought a herd of attorneys with me.
Oh, I see.
Fantastic. Since your last meeting, the City Council has met twice, Monday, January 27th and Monday, February 10th, 2014. Of interest to you in the January 27th meeting, the final plat of Westbrook at Creekmore 9th plat was unanimously approved for the 23-lot single-family subdivision along Creekmore Drive in the Creekmore subdivision. And then something you and Commission had worked on hard in new business, the 17th amendment to the Unified Development Code, which I believe is going to allow some special type of lighting fixtures and inflatable signs to be taken care of at the staff level, and was kind of an improvement, which was your non-controversial, as I understand, at the commission level, because I know this one was tough, because I got a call in the meeting of another meeting from Jonathan Zer that you guys were up to it here, and he wanted to know if we could separate that into two, and Jonathan really takes care of you guys just fine without me, so I knew we were in deep yogurt somewhere here. So.
I'm sorry, but
Well,
that is
it's good to still be
humorous in
normal.
retrospect. It wasn't so
More
funny
intense than
that
one
evening.
tonight, but that night was good. And then that was because you broke off into the 18th amendment
Right.
to the unified, so that the first part got a 7-0 vote.
Right.
The next one was the 18th amendment to the Unified Development Code, which was the accessory dwelling units in agricultural, rural estate, and rural residential zoning districts. And both on first and what we'll get to in February 10th, second reading, this was a hotly discussed and contested issue. The first night on the 27th, it went through 6-1 somehow with only Councilman Westcote approved. But when we came back on Monday night, February 10th, and it was one of those nights where there's going to be a series of contentious meetings. Somehow somebody got in a resolution about the Kansas or something supporting the Kansas City School District, and I almost didn't have a city council left by the time we got to the Unified Development Codes. The split on that was really wild, like a 3-2-3 vote, Mr. Chairman. So if you want to really like to know, if you've got 8 there but 3 abstained, How does the vote work? Wow. It's what turned me gray down here, you guys remember. So anyway, on that night, again, the 17th Amendment rolled through with no problem, but the 18th Amendment, as I recall, went to a 4-4 vote, and our mayor broke the tie in favor that it passed. So your accessory dwelling units now are a permitted use. I will note for the record that one council member who said he didn't have that right thought it was a good idea on this particular night, but it's all good. Also, another controversial issue that's been hard, I'm not sure it's a planning issue, but you've got to follow the community civic center feasibility study, because that's taken a real checkered path through the process, and I think we are now at the point where there's going to be a survey and feasibility? Market analysis.
Thank you.
The survey and market analysis. So we'll see what comes out of that to see if that idea of having a community civic center moves forward or not. Past that, I don't know if the property maintenance code really goes, no. I think those are the main issues that would be in
Now, if I may, I'm not trying to time you here, Mr. Willerth, but from the Raymore Journal, February 13th edition, a long article about Raymore Council meeting on February 10th, and there's one mention there, and if you don't mind, it's probably better if I just read it verbatim. In another resolution, guidelines were set for city personnel providing information to the public through the production of video news updates. The guidelines basically cause appointed officials to abide by the same rules as city staff members. And I would ask if you remember that particular discussion from city council, are we considered appointed officials, since commissioners are indeed appointed by the mayor? And is there anything we need to know about that? Ah, Mr.
I will let
Berlin?
the author of that outstanding piece of work and guidance going forward.
We are
He's
honored.
also making guest appearance here tonight.
We are honored to have Mr. Berlin here this evening and appreciate your advice.
Sure, thank you, sir. Yes, we have begun producing video news updates. So far, I've been the only person on camera. But elected officials, certain elected officials have indicated that they might like to do something like that from time to time. So some guidelines to just sort of, just a few rules to sort of guide those kind of presentations were drawn up. During consideration of those, it was actually somebody from the park board who said that they asked if appointed boards might also be included, and the council did want to include appointed boards, which does include the Planning and Zoning Commission. So if any of you are interested in appearing on camera to talk about an issue, you're welcome to do it. But one thing that is in those guidelines is that you would be restricted to matters that are in the planning and zoning realm. So you couldn't come to talk about a Parks and Recreation matter as a Planning and Zoning Commission member. But yes, you do have that ability, and we have developed a very fairly minimal set of rules to guide how those kind of presentations would be made.
Okay, so in your opinion, for now, we don't really need any further understanding of those guidelines, but
I'd be happy to supply them to you.
Should we?
I'll ask Mr. Carteret to make sure that you each have a copy, just so
fine.
you can see what they are.
I was really just kind of questioning whether they were applicable and if there was really anything we needed to know, but yeah, certainly I think Commission would appreciate seeing that as well.
They do apply to the commission, and I'll be happy to make sure that that you get a copy.
I appreciate your time this evening. Thank you, Mr. Berlin. And Mr. Willard,
And
back
none
to
of
you.
you want to appear on the stream setback issue yet, because you have an open mind and you are still waiting to intake all evidence before you go public with any position. Thank you.
Thank you very much for that guidance, and yes, I could assume that none of us would care to do that, but I should never assume things, should I? So I think that concludes City Council report, and that would say Mr. Willard, I'm sorry, Mr. Carteret, if you'd like to give us the staff report in the planning pipeline.
Yes, sir. Our next meeting scheduled is March 4th. We have a couple of public hearings scheduled for on that meeting, both related generally to the same area. The David Otis, who is here this evening, representing Good Otis and the Good Ranch, filed 2 applications pertaining to land area that's located on the south side of North Cass Parkway, adjacent to and east of Interstate 49. They're requesting to reclassify a little over 34 acres of land along North Cass Parkway. Currently, it's all zoned agricultural. They're asking to reclassify the 34 acres directly adjacent to the Cass Parkway from agricultural to C3, regional commercial. And then south of that acreage is an additional 113 acres. They'd like to reclassify the zoning to business park. And then, and this land area would be between Interstate 49 and what would be the future extension of Dean Avenue going south of North Cass Parkway. And then on the northern portion where they're asking for the commercial zoning, they propose a 10-lot commercial subdivision. So we'll have a public hearing on the preliminary plat for that subdivision. You saw a glimpse of it this evening during the presentation. Both of those public hearings again scheduled for March 4th. And then the only other item we currently have scheduled is now on your March 18th agenda for stream setbacks.
Right. Yep.
That's all
Good.
I have, sir.
Thank you, Mr. Carteret. At this time, I will open the floor for public comment. This is yet another opportunity. If you wish to address the commission on any particular topic, please feel free to come forward to the podium. And seeing no one, I'll open the floor for commission member comment. And would anyone like to go first?
I'll go first.
Thank you, Commissioner Pfizer.
I'm going to make a shameless plug for the Ray Peck Theater's performance of Putnam County Spelling Bee this weekend. I think if you haven't been to one of their performances, they are amazing. And my son will be playing the part of Leaf Honey Bear. And my daughter's an assistant director. But beside that, they're very good even when my kids aren't in them. But they're performing Thursday, Friday, and Saturday night, and Sunday there's a matinee, so.
And that's at Ray Peck High School.
It's at Ray Peck High School. It's like $5 or $6 or something like that. So it's great entertainment. I just want to make my plug there.
Well, thank you, Commissioner Pfizer. So now that we've broken the ice, Commissioner Meiske.
No comment.
Yeah. Okay, let's see. Commissioner Crane.
Thank God the snow's gone.
Oh, no.
That just means it's gonna snow now.
Sure, I'll agree with that. Commissioner Anderson.
No comment.
Vice Chair Burke.
No comment.
Let's see, have I forgotten anyone besides Mayor Kirkhoff? Sir?
You've jinxed it by saying the snow is gone.
Oh, now I see the concern.
Yeah,
Right,
yes.
never speak too
Other
soon.
than that, no comments tonight.
Did I miss anybody? Okay. As always, but it's not a broken record. I think this evening's case and the work involved reminds me once again how grateful the commission is to city staff, Mr. Willard, Mr. Krass. This is very much a team effort. Mr. Berlin, thank you for that input as well. This is very much a team effort, and the commission could not do what we do without the expertise and the legwork from city staff. So I appreciate that very much. And I believe Mr. Willerth answered my other question earlier, so unless anyone has anything else, I would entertain a motion to adjourn this evening's meeting. Mayor Kirkhoff.
So moved.
Second.
And second by Commissioner Meiske. All those in favor of adjournment, raise a hand, please. Let's see, you've thrown my count off. I see 8 hands, but I think it's 7 in favor, none opposed, no abstentions. So thank you all very much. I was trying.
I'm looking forward to seeing what comes back on the 18th.
On what?
On the 18th, what comes back.
Yeah, I am too. I am too. that,
It's always good to keep things Somebody know what my big question is? Business related.